A man in red pulled from a car while on vacation right in front of his wife. The man in handcuffs, a police chief on leave accused of sickening crimes.
You all right?
Yeah, I'm a little stiff.
Yeah, we're gonna go that way.
And a big twist from the person closest to him, his own wife, as the story behind this arrest is shocking. I'm Anjanette Levy, and this is Crime Fix.
Clermont County, Ohio, returned by a grand jury and attached to the name of a man who had spent more than 2 decades as a law enforcement officer. A man who, at the time those charges were unsealed, held the title of police chief. The gap between those two facts is not incidental to this story. It is the story. There is an image that keeps surfacing when you sit with this case long enough. A basketball hoop in a driveway. The kind of detail that shows up in every neighborhood in America. The kind of detail that means nothing and everything. The indictment runs 70 counts. 70 separate felony charges, filed in at the same time. Because it represents exactly what this case keeps forcing you to confront. The deliberate, practiced distance between the face a person shows the world and the record that eventually surfaces in a court filing. When the two collide, the basketball hoop doesn't disappear. It just means something different now. This is the Dark Discovery Files. We don't speculate. We follow the documents. If this kind of case-by-case evidence breakdown is what you're looking for, subscribe now, because we stay with the record long after the headlines move on. According to public court records and statements made by the Clermont County Prosecutor's Office, Chad Essert served as a police officer in Ohio beginning in 2003. By 2021, he had reached the top position in a small village in southwest Ohio, chief of police. 20 years on the job, a rank that carries institutional trust, legal authority, and daily access to the machinery of the justice system. And then, in June of 2026, that same justice system came for him.
Chad Essert has been a cop for more than 20 years, since 2003. In fact, he's been the top cop, the chief in a small village in southwest Ohio since 2021. His record hasn't been completely spotless, and now it's forever tarnished. But the village he leads isn't waiting around. There are already big moves underway to force him out, and I'll have details for you on that a little later on. This after a grand jury in Clermont County, Ohio, east of Cincinnati, indicted Chad Essert on 70 felony charges related to allegations.
A grand jury in Clermont County returned an indictment charging Essert with 70 felony counts. The charges included 56 counts of sexual battery and 14 counts of unlawful sexual conduct with a minor. According to the prosecutor's public statements, the alleged conduct spanned 5 years, from 2005 to 2010. The alleged victim was a young girl who was 12 years old when the conduct is said to have begun. She is now a woman, an accomplished Marine, and according to law enforcement, she is the one who came forward.
That he had sexual contact with a young girl during his time as a police officer. The prosecutor says the girl was part of the Young Marines, a program for kids and teens to learn about being in the Marines. The accuser is now a woman who's an accomplished Marine. The sheriff said she recently came forward and reported the allegations to detectives. Those allegations included claims that Essert wrestled with her and took her swimsuit bottom off when they were together in a pool. In all, the prosecutor says Essert committed sexual battery against the girl starting when she was 12, from 2005 to 2010, in 2 different counties.
That timeline deserves a moment of stillness. 20 years passed between the alleged beginning of this conduct and the indictment. The girl became a woman. The woman joined the Marines, built a career, built a life. And at some point, she walked into a sheriff's office and reported what she says happened to her when she was 12 years old. The prosecutor's office did not wait long after the indictment to move. On June 11, 2026, deputies in Pinellas County, Florida, located Essert while he was on family medical leave. He was not in Ohio. He was on vacation with his wife. According to body camera footage and public statements from law enforcement, the arrest happened in a parking area, the couple preparing to leave for the grocery store. His wife was in the car when deputies approached. She was told, on the scene, that her husband of 8 years was being taken into custody on warrants for the rape of children.
You got your phone on you?
No, it's in the car.
Can someone come here?
Yeah, he's got warrants.
Warrants for what?
We're good to tell her what everything's for? Rape of children.
But children? Who is?
It's not our investigation. It's probably...
By all accounts, she had no knowledge of the charges. She was, in the words of those present, beside herself.
On June 11th, 2026, deputies in Pinellas County, Florida, tracked down Essert to pick him up on a warrant.
Clear.
He built a professional identity. That is the first thing to understand about this case. According to public court filings, Essert did not simply come into contact with the alleged victim by chance. Prosecutors allege he used a specific pathway to gain access. He became involved with the Young Marines, a program for youth interested in learning about military life and service. He later obtained employment as a junior ROTC instructor and substitute teacher, according to court documents. He represented himself to that program and those institutions as an active duty Marine infantry reservist who was advancing in rank. That representation, according to the prosecution, was false. Court records indicate that Essert had in reality received an administrative discharge from the Marines, classified as other than honorable, after refusing to attend required drills and infantry school. He was not advancing. He had, by the military's own accounting, failed to fulfill his obligations. And yet he used that fabricated military identity to position himself inside institutions that placed him in authority over young people. According to investigators, including the alleged victim herself, he built a professional identity. That is the pattern prosecutors describe.
Prosecutors say Essert, a one-time young Marine instructor, abused his position to target a girl in the program over those 5 years, starting when she was 12.
Using that status, he became involved with the Young Marines program and later obtained employment as a junior ROTC instructor and substitute teacher at Great Oaks, again placing himself in positions of influence over young people, including the victim. The defendant gained these positions holding himself out as, again, active duty Marine infantry reservist who was moving up in rank, when in reality he had refused to attend various drills as well as infantry school, resulting in an administrative other than honorable discharge. The allegations describe a prolonged pattern of grooming and sexual exploitation by the defendant rather than a single lapse in judgment. The conduct is alleged to have continued for years and across multiple counties.
The charges allege the conduct occurred across multiple counties, Clermont, Hamilton, and Warren County among them, according to statements made in open court. This was not, according to the prosecution's framing, a single incident. The language used in court describes a prolonged pattern of grooming and sexual exploitation rather than any isolated lapse in judgment. The alleged conduct began when the victim was 12. It continued, according to the indictment, until 2010, when she was 17. 5 years. Across multiple jurisdictions.
Prosecutors say they have witnesses that corroborated some communications and interactions between the two. The judge set Essert's bail at $500,000. He can put up property to post some of that. So I want to bring in Jay Clark. He is representing Chad Essert on these charges out of Clermont County.
From someone who was simultaneously serving as a law enforcement officer. Here is the question that reframes everything you have just read. If a man spends 5 years allegedly committing sexual crimes against a child across multiple counties, while simultaneously wearing a badge and a title that place him above reproach in his community, at what point were the systems around him designed to catch that? And if those systems existed, why did it take 2 decades and one woman's decision to walk into a sheriff's office for any of this to become a court record? When Essert was extradited back to Ohio and appeared in a Clermont County courtroom for his arraignment, he entered a plea of not guilty on all counts. His attorney, who came to the case through a referral from Essert's divorce proceedings, stated publicly that his client maintains he did not do these things.
Guilty plea, obviously. These allegations go back to 2005 through 2010. So this is a pretty old case, going back as long as 21 years.
Right.
He's saying he didn't do it, but the prosecution is saying they have some communications between this accuser and your client. They have some witnesses to corroborate some things in this case. What is your response to that?
I think that might be somewhat accurate and somewhat a wish list. I think that there might be witnesses to communications between them, but I think if they drill down based on what I've been told, those are going to be communications from the accuser to Chad, not coming from Chad to her. It's going to be her reaching out to him.
The defense has noted that the allegations span a period now more than 20 years in the past, that the case will likely come down to the testimony of the accuser against that of the defendant, and that the defense intends to pursue its own investigation of the evidence. The attorney indicated there may be electronic communications that will factor into that defense, though acknowledged the passage of time makes retrieval uncertain. The prosecution, for its part, has stated it has witnesses who can corroborate communications and interactions between the accused and the accuser. Whether those communications support the prosecution's theory or the defense's competing narrative will be a matter for the trial that appears likely to follow. The judge set bail at $500,000. Essert posted bail and was released. He is scheduled to return to court.
When deputies picked up Chad Essert on the warrant for the 70 sex crimes charges out of Ohio, he was on family medical leave, spending time in Florida. He and his wife had been at the beach. Deputies snapped this photo of Essert wearing a T-shirt marked "Day Drinkin' like Abe Lincoln." Chad Essert was booked into the Pinellas County Jail in Florida. He waived extradition back to Ohio to answer to the 56 counts of sexual battery and 14 counts of unlawful sexual.
He built a professional identity. He used it, and for more than 2 decades, according to the public record, it held. There is one additional layer to this case that the court record does not answer, but that the institutional context demands be asked. Essert was not unknown to oversight mechanisms before this indictment. According to public statements from his defense attorney, there had been a prior, entirely separate investigation into his conduct as a police officer. That investigation, according to the attorney, centered on allegations that Essert had used his department's police cruiser to drive to another city and engage with a woman he had connected with through an adult content platform. That investigation, according to the attorney's public statements, concluded with a finding that no crime had been committed. What is notable about that prior investigation is not its outcome. It is its existence. A law enforcement officer was investigated for conduct involving his official vehicle and his personal behavior. That investigation closed. He remained chief of police. And then, according to a grand jury, the deeper record surfaced. The defense attorney himself observed in public statements that the earlier investigation seemed to be what drew attention that eventually led to the sex crimes inquiry. That chain of visibility, from a lesser allegation to a grand jury, raises a question that institutions rarely answer cleanly. What does it take to look closely?
He's got, he had some other things going on in his position with the city or the village of Bethel, I should say. There was an allegation and there was an investigation completely separate from this, totally separate, where it was found that he committed no crimes. He was, I guess, under investigation for using his cruiser to drive up to Dayton to interact with a woman up there who was on OnlyFans and have some interaction with her. And he was not found to have any, he was found to have committed no crime there. And right. That's, it seems like the smoke from that kind of led to this investigation.
And what keeps people from looking before they have to? The village mayor of Bethel, Ohio, where Essert served as chief, publicly stated he was deeply disturbed by the arrest. Under Ohio law, a mayor who believes a police chief has engaged in unacceptable conduct may file written charges with the village council, triggering a hearing and a potential removal vote. That process, according to public statements from Mayor J.D. Noble, was already underway as of the date of the arraignment. The village was not waiting for a conviction. The process of institutional separation had already begun.
So what happens to his job in all of this? Well, Bethel Mayor J.D. Noble says he is deeply disturbed by the arrest and has already begun the process to force Essert out. Under Ohio law, if a mayor believes a police chief engaged in unacceptable behavior, he or she must file written charges with the village council. Noble says he intends to file those charges as soon as legally possible. From there, the council holds a hearing after the charges are served, and council members can vote on whether to remove him. Essert is scheduled to return to court on July 7th. If convicted on all charges, he could face up to...
If Essert is convicted on all 70 counts, the sentencing exposure, according to public reporting, is up to 280 years. That figure is not a prediction. It is a reflection of what the charging documents allege and what Ohio law attaches to those charges in the aggregate.
280 years in prison, but as you heard, he has posted bail and he is free on bail right now. So we'll keep you posted on what happens in this case.
The case remains pending. No verdict has been reached. All charges remain allegations until proven in court. But the document that does not wait for a verdict is the indictment itself. 70 counts, filed by a grand jury of ordinary citizens who reviewed the evidence presented to them and found sufficient probable cause to send this to trial. That is not a conclusion, but it is not nothing. There is something in the public record that keeps pulling attention back to the start. When the alleged victim first came forward, it was not to the police. It was not to the prosecutor's office. It was not to the sheriff's department. According to statements made in open court by the defense attorney, her first public account was given in an interview on a local YouTube channel. She told that interviewer, and this is part of the record now, that she was not seeking consequences for the man she was describing. Her words, as characterized in court, were that she simply wanted people to be aware.
And I'm not going to say more than that, but the thing I will point out is she didn't contact the police, the prosecutors, the sheriff's department. She got her 15 minutes of fame on a YouTube channel with somebody here locally. In fact, even in that interview, she said, I don't want anything to happen to him. I'm not out for that. I just want people to be aware. And so I don't know if she's now gotten more than she intended by going on that YouTube and doing that interview, based on the detail that the prosecutors mentioned in court yesterday.
She did not know what Aware would become, because Aware became a case number. Aware became a grand jury. Aware became 70 counts and a bail hearing and a man in handcuffs in a Florida parking lot, and a wife sitting on the curb being told her husband had warrants for the rape of children. Aware became a Clermont County courtroom where Essert stood and heard the charges read, in a room where he had likely testified as a witness for the state on other people's cases over the course of a 20-year career. He built a professional identity. He used it to move through institutions for 2 decades. And a young woman, 12 years old when this is alleged to have started, eventually decided that the people around her should know. The Clermont County court docket for this case is publicly accessible. The indictment is part of the public record. The prosecutor's sentencing memorandum and case filings will be added to that record as the case proceeds. If you want to follow the evidence rather than the commentary, the Clermont County Clerk of Courts maintains those records, and the case docket can be accessed through the Ohio court system's public portal. Look at the charging document. Read the count-by-count allegations. Read what the prosecution alleges happened in those 5 years across 3 counties, and then consider this. The Young Marines program, according to statements made in connection with this case, no longer exists. There is no active roster. There is no institutional memory to contact. There is, according to the defense attorney himself, nobody obviously around to ask, which means that whatever full accounting of this program's history might have been possible at one point is now significantly harder to reconstruct. That is not an accusation. It is a structural reality. Programs end. Records disperse. The people who pass through them scatter. And the children who were 12 years old in 2005 are adults now, many of them living lives that have nothing to do with a case file in Clermont County, Ohio. If you were part of the Young Marines program in Southwest Ohio between 2003 and 2010, and you have information you believe is relevant to public accountability in this case, the Clermont County Sheriff's Office and the Prosecutor's Office are the appropriate contacts. The investigation, according to statements at the time of Essert's arrest, remains active. This is not over. The trial has not happened. The full evidence has not been presented in open court. The defense has not had its opportunity to cross-examine or present its case. All of that is still ahead. What is already in the record is the indictment. What is already in the record is the 2 decades. What is already in the record is a woman who was 12 years old, who became a Marine, who sat down in front of a camera not because she wanted consequences, but because she wanted people to know. He built a professional identity. He wore it for 20 years. And then the record caught up. What is your read on the institutional systems that surrounded this case for 2 decades? Does the sequence from a prior misconduct investigation to a grand jury indictment suggest those systems worked, or does it suggest they were never really designed to catch something like this? Drop your analysis in the comments. If this breakdown gave you something the headlines didn't, like this video, share it with someone who follows cases like this, subscribe to the Dark Discovery Files, and turn on notifications. The case continues. We will follow the documents.